Yeah, it feels a little less.
You can throw stuff at me.
All right, while we're getting situated here, I'm Lauren McCartney. I'm the CLA director here at the College of Law. A few of you have approached me to ask about ethics credits. Because this seminar does not offer any ethics credits, we are going to offer us a discount on if you'd like to supplement your seminar with some ethics credits from our digital package. So just go ahead and pick up a sheet out from me, and you'll have a discount code there. So thank you.
I guess with that, we're ready. Welcome to this afternoon's panel. I'm Jamie Van Nostrand, the moderator. The topic of this panel is home rule and the environment, exploring how municipalities address environmental policy gaps, including farmland, solar policy, and pipeline routing. And we have three presenters today, participants. After they do their presenting, we'll have a discussion. We're going to start off with Sarah Foxx, who's going to be talking primarily about state preemption of local environmental efforts, in particular instances of state preemption of local action where no state regulatory framework exists. Sarah is at the Northern Illinois University Law faculty. Her primary research and teaching interests are the intersections of environmental law, property, and land use. Prior to that, she was at Georgetown, where she received both her JD and LLM. After Sarah, we're going to hear from Heidi Robertson, who's the Stephen W. Percy Distinguished Professor of Law and Director of Student Success at Cleveland Marshall College of Law at Cleveland State. She holds a joint appointment there with the Cleveland State University's Levin College of Urban Affairs, where she is Professor of Environmental Studies. Heidi's going to be presenting on a case study for local governments in influencing natural gas pipeline permitting, the importance of borders. And presenting third will be Genevieve Byrne, who's with the Farm and Energy Initiative at Vermont Law School and part of the Institute for Energy and Environment at Vermont Law School. And she'll be presenting on state versus solar siting authority. Genevieve had her JD from Lewis and Clark in Portland. So with that, let's start off with Sarah.
Great, thank you. So the way I think this panel is going to go is I'm going to present much more of kind of a high-level overview of some of these issues, and I'm very interested to hear about the more specific examples. But what I'd like to talk about is this kind of idea of preemption of local ability to act on environmental issues, especially where the state has not engaged in any type of action. So it's a very specific kind of preemption, but it's one that I've already heard about in some of the preceding discussions and certainly at lunch, right? This idea of the fact that it might be a little bit different, right? That there's something different about local governments acting in the absence of any kind of state or federal action. And the reason I think it makes sense to look at this from the environmental law perspective is that a lot of times if you dig into kind of environmental law literature, you look at kind of the story of environmental law, it's often presented as a story of gap filling, right? There's kind of the early history where local governments would act in terms of zoning, other kinds of forms of common law remedies to address environmental problems. States stepped in to a certain extent to do that as well, but then overwhelmingly, right, through, for various reasons, those were not ultimately enough to address the kinds of complex environmental issues that were starting to arise. And that's where we see kind of the advent of the federal environmental law statutes coming in the 1960s, 1970s, to fill in some of those gaps to help kind of achieve greater environmental protections where there were failures at the state and local level. And for a while, that's predominantly where we saw environmental law action taking place, right, is at the federal level. Certainly with some delegated authority to the states, right, a lot of cooperative mechanisms, but by and large, looking to state and federal actors to kind of address environmental problems. Now, obviously in 2020, right, that landscape looks a little bit different. We have a federal government that has been pretty willing to, either deregulate or to kind of devolve a lot of authority to the states. We have a lot of states, right, that have not been particularly interested in acting on environmental issues, particularly some of the complex issues like climate change. And at the same time, right, we have local governments that are, in fact, doing a lot of work on environmental issues. And that's why I'm so excited to hear about some of these more particular examples. But, just broadly speaking, right, we see that in the areas of fracking. We see that on the issues of things like plastic bag bans. We see it on a lot of water issues. We see it on a lot of kind of other many environmental issues here, things like climate change, right? That local governments are in fact stepping up and trying to, again, fill in what I would characterize as kind of a gap in authority in kind of environmental protections here. All right, so obviously we're talking about this in the context of home rule, right? And so it's not just enough to kind of look at well, the fact that local governments are acting, right? But it's also that interaction between the local governments and the states. And I know it's not surprising to anyone in this room, right, to hear that, in fact, as local governments have started to act on a lot of these environmental issues, we've seen states stepping in to remove their authority to do that, right? Not only by asserting, or putting in place a state regulatory scheme, but in fact by just taking away the authority of local governments to act on those issues. So, for instance, the classic example I always rely on is the plastic bag bans, right? Because, to me at least, it seems like one of the most clear-cut and kind of egregious examples of this, where we see, cities across the country, either imposing a fine or just a ban on the use of plastic bags, plastic containers, and states then stepping in to say, no local government in this state, right, may enact such a ban or a fine, right? It's very clear cut. The only thing that legislation is doing, right, is removing authority from the local governments to act. Okay, so, from one perspective, right, maybe that's just politics in action, right? Maybe that's just the way that home rule works, right? Certainly states have a great degree of authority to take away local power to enact, a variety of mechanisms. But I also think it's worth exploring a little bit more what those forms of really deregulatory preemption mean for the way that environmental law is going to function, right? Because if you do look at it from kind of a home rule lens, maybe there's not that much to say about it in some ways, right? You can say, that it's maybe outside the spirit of home rule, right? That it's not really what home rule statutes were designed to do. But from the other perspective, again, home rule, it makes available these broad preemption measures, right? And it's not really outside the bounds of that necessarily. But I don't think that that means that it's not worth kind of thinking about, again, in terms of the broader ways of what that means for environmental law and environmental protections. All right, so if we think about it from that perspective, right, I think that it becomes possible to bring local governments into the broader conversation of things like environmental federalism, right, that they have not necessarily been part of before. And that's what I'd kind of like to propose as kind of a new perspective to add here, is that we start thinking about the ways that preemption is actually impacting the ways that environmental federalism, environmental governance are kind of going on in the country. Because again, if we think about it, if we kind of take this more classic narrative of gap filling, it's really eliminating part of that ability to fill in gaps in some pretty substantial ways, I would posit. All right, so if we, obviously that's going to require digging a little bit into, what is environmental federalism more broadly, right? At the in the kind of classic presentation, right, federalism is of course describing this dual authority, allocation of authority between the federal and the state governments. We don't see an explicit role for local governments within the Constitution and within the classic federalism conversation. But another reason that I think environmental law has something to add here is that just hasn't been the case historically in the context of environmental federalism. So if you look at kind of the conversations about how does environmental governance work in the United States, how does environmental federalism work, you see that it's never just been about this kind of allocation of roles between the federal government and the state government. It's been focused on a much more dynamic relationship among those governmental levels. And so you see discussions of cooperative federalism, of things referred to as dynamic federalism, and really emphasizing again that need for different levels of government to step in at different times to fill in these regulatory gaps, getting at this overall goal of kind of environmental protection, or at least the ability to discuss these avenues for environmental protection. All right, so if we're then in a world, right, where we have one level of government that's just essentially cutting off the ability to play that gap-filling role, then we need to start thinking differently, I would argue, about how environmental federalism actually plays out. And I think that's important just as kind of a reality check, right, in terms of thinking about the possibilities for environmental protection and environmental law. But I actually also think it's important because it might offer, I think our lunchtime speaker suggested that we need to give judges something to go on, right? That there's a need to point to something outside of home rule statutes if we want judges to be able to conceptualize why it matters that local governments are losing authority, and why it matters, right, that they should be maybe focusing on or be willing to give a bit more deference to local governments. And I think that this is maybe a way to at least offer them a reason to do that, right? Because it's not it's certainly well within the bounds of kind of the federalism conversation for judges to focus on that, right? To focus on the ideas of federalism as a reason for preferencing one level of government versus another. And that may be the case here as well. So to dive into a little bit more what that would mean, again, if you kind of refer to the environmental federalism conversation, what that conversation focuses on mostly is the idea of federalism, again, not as kind of two dual entities, but on really a governance mechanism that gets to certain values, all right? And so if we start thinking about the values of federalism, those vary from discussion to discussion, but are generally focused on things like accountability, experimentation, voice or participation, and really aimed at kind of getting at what level of government, right? Assigning authority to what level of government is really going to get us to the attainment of those federalism values. And again, I think if we look at federalism, or environmental federalism at least, from that perspective, it becomes clear that taking away authority from local governments to act, particularly when there's no action at the state level, is going to undermine some of the ability to get at certain of those federalism values. And again, I think this is certainly true across the board, but I think environmental law offers a really good way to kind of look at the kind of impairment of some of those values, both because that's already part of the conversation here, but also because there is this kind of broad tradition of participation at the local level, the state level, and the federal level. And there's just recognized interest at all of those levels as well, right? So environmental law has always been something with a strong local interest, a strong state interest, and a strong federal interest. And that's part of the reason that it's been such contested territory over kind of who gets to dictate what environmental protections are going to be in place and who gets to decide those things. All right, so, all of that is to say, I think that environmental federalism offers a new lens to get at what I would call these kind of regulatory gaps or regulatory vacuums put in place by certain forms of kind of deregulatory preemption. If we start looking at that then through the context of, how do judges normally assess this kind of preemption, right? Again, I don't think it's any surprise to people here that in the context of state and federal preemption, there are certain protections in place for state actions, right? There are things like the presumption against preemption that is often used by the Supreme Court and other courts to avoid kind of finding that a federal statute preempts a state statute. That's not present, right, in the state and local context, at least as how home rule statutes operate currently, right? But it is a protection that kind of operates at that level. We can see other preferences kind of against these forms of regulatory gaps. If we look to things like tort law, again, where the Supreme Court has explicitly kind of, construed statutes to avoid these kinds of regulatory gaps. And we can also look to kind of the court's conversation about when and why these kinds of regulatory gaps are going to be allowed, looking to things like the fact that sometimes, federal preemption of state statutes is going to be allowed because, we think that states are adequately represented at the federal level, right? Or because we think there's a certain amount of policy or process that's in place in the passage of federal statutes that'll provide certain protections. And again, those things aren't necessarily present at the state and local level, right? In the context of representation, there's been an enormous amount of conversation around gerrymandering, right? The fact that a lot of cities are not actually adequately represented at the state level. And on the question of process, there's actually been a lot of research currently going on that I believe is going to be published soon about the kind of lack of process that goes into some of these state statutes also preempting local functions. So if we look to all those things, right, again, we get to this idea that what's happening here is maybe fine, on the surface within the context of the home rule conversation, but it's troubling in the ways that preemption conversations have occurred in other contexts, and it's troubling in terms of getting at the actual values of environmental federalism and perhaps federalism more broadly here. So my proposal would be to kind of start rethinking a little bit about how we think about environmental federalism and governance, and how to bring local governments into that conversation a little bit better, okay? So to do that first, I think, first of all, we just have to recognize that in the context of environmental law, local governments provide certain benefits that states don't necessarily, right? Particularly within the context of these federalism values, perhaps more broadly, right? So if we think about what it means to have, certain environmental issues going on often, right, those are very kind of local in nature. They're at once maybe local in nature and more broad, but there's specific local conditions that are being responded to, right? And the nature of environmental conditions is that across the state, those conditions are going to vary widely. They're going to vary in terms of kind of the density of population, but they're also going to vary just in terms of, you know, where the water supply is, or what the groundwater conditions are like, what the soil conditions are like, right? There are these kind of hyper-local environmental conditions that make it necessary for local governments to respond in ways that might not apply statewide. And if we think about those again in kind of the context of federalism values, it really gets at this idea of experimentation, right? How are we going to solve these kind of diverse problems? Maybe that part of that is by allowing local governments some room, some breathing room to try and address those things. It also goes to this idea of accountability, right? Voters want, you know, officials in office that can respond to their specific concerns, and this is one way to, you know, that they are able to do that. And I think it's worth pointing that out because a lot of times kind of the value of state action and the value of local action are conflated a little bit, right? There, we kind of refer to states as being able to provide this experimentation function, this kind of accountability function, when what we actually mean is that local governments are providing that, right? That the experimentation that's actually going on is the local governments within the states. Within the kind of state and local preemption context, I think it's really important to kind of parse, you know, who is doing that kind of experimentation and who is playing that role. All right, so if we acknowledge that, right, if we kind of acknowledge for the minute that local governments are providing something distinct from states, then I think step 2 is acknowledging that by kind of engaging in deregulatory preemption, by taking away the authority of local governments to engage in some of this experimentation and these actions, we are actually harming environmental federalism values, right? And we're doing that, I would say, by creating these kinds of, again, what I would call maybe regulatory vacuums or regulatory gaps, right? Areas where that kind of experimentation is no longer going on, right? And that, again, has been disfavored in a variety of contexts. And I would say it should be disfavored in the kind of state and local context as well, even if it's allowed, right, under kind of home rule frameworks. I think there are broader reasons for kind of disfavoring that. I think there are reasons, right, for thinking about the kind of impairment of federalism values, again, from the experimentation front, right, for what it's going to do in that context. I think there's even reasons for thinking about it and disfavoring it from the environmental justice standpoint, right? There's a lot of times when local communities, especially communities that have been more disproportionately burdened by environmental harms, are working to address those harms, and taking away the power to allow them to do that is going to undermine kind of the attainment of some of those environmental justice benefits, and it's going to undermine that, therefore, kind of some environmental federalism values as well, because justice is really, and equity is built into that framework. All right, so then what do, right? We acknowledge that. We acknowledge that, yes, there's benefits from local governments. Yes, we might be impairing federalism values. And I think what that means is that we need to start having much more localized conversations about how environmental federalism and how environmental governance is actually playing out across the country, right? It's not possible necessarily to have just national conversations about what environmental federalism, what environmental governance is, because it varies so much by state, by home rule framework, by kind of the various preemptive measures that are in place there. And that allows us to have much more realistic conversations, I would say, about the potential for local action on things like climate change, right, which varies widely across the country. And it also allows us to point out maybe to judges even where those values are in danger, right? Maybe that's something that can be brought up even in the context of litigation as sort of, you know, just a more policy argument for why this kind of deregulatory preemption is harmful, even if allowed under home rule frameworks. So I think that's all I will say for now, but I'm very interested to hear more explicit examples of kind of this undermining of local authority.
Okay.
Next, we have Heidi Robertson.
Let's just make sure this. Okay, so you've been, is this on? I don't think I need it, do I? I'm good? Okay, so you've spent a day and a half looking at faces with no pictures, and I'm here to break that cycle. I apparently did not get the memo that that we weren't using PowerPoints. So neither did our fearless leader, who asked us to set stuff. Okay, so you've heard a lot about what municipalities can do with the benefit of home rule, what they cannot do, even with home rule, and the role of preemption when home rule doesn't protect the municipality when it acts in a space where the state prevents that action. And I think we've heard a couple of themes. One is some frustration on the part of municipalities when they would like to act, but home rule isn't broad enough or has been interpreted as being more narrow than the actions they'd like to take. Some frustration there. And Sarah was talking about variations among states. We heard a little bit about that at lunch too, about what all this means varies state by state. So I look into these issues really at the intersection of local government law, natural gas development, and legislation and regulation. I mostly work on issues in Ohio, but often comparing Ohio to what's going on in nearby states. And in particular, I'm looking at what local jurisdictions and their citizens can do to achieve their intentions or their goals in the face of preemption in the broader context of what should be home rule. So let me start by telling you briefly how I got here. And that is, I've written a few articles on related topics, and I'm just going to kind of quickly tell you why it's related to what I'm doing. The first article in this little series that I've been doing is about state variation in local control within a shale region, and that has to do with local governments that want to have an influence on oil and gas decision making. I'll talk about that in a second. The second is on landowners who want to avoid drilling beneath their land, and landowners, obviously, some of them are local governments, and what authority do they have there? And then this article is really a case study about local efforts to influence natural gas pipeline routing decisions. So I'm going to just talk for a minute about the first article, because also it kind of gives you some background about Ohio. This one is about state variation in local control of oil and gas decision making within a shale region, and it really focuses on that these variations are tied to key differences amongst the states in 3 areas. And kind of the big point there is that borders matter enormously in what local jurisdictions can do. I'll come more back to that later. But the 3 areas within a shale region that lead to local jurisdictions having completely disparate abilities to control oil and gas related decision making, obviously, are what is the state constitution under which that local jurisdiction is operating? Is there a home rule provision and or an environmental rights provision at play? Second, state legislation. Is there preemption, either by broad subject area or specifically directed at whatever the local jurisdiction is trying to do? And third, what are the possibilities with respect to local ordinances having to do with location or permitting or zoning? So this article looks at sort of 3 states within the same shale play and analyzes the differences in these 3 areas and their impact on the ability of local jurisdictions to regulate, sort of resulting from differences in these areas. I'm going to skip this second one because there's not enough time, really. But what I'm working on now is this third piece, which is looking at including local governments' efforts to influence natural gas pipeline routing in a context of a constitutional home rule state where the legislature has by statute specifically preempted local jurisdictions from taking really any action related to oil and, the natural gas, oil and gas industry. And this project relates specifically or primarily to the city of Greene, Ohio, which is near Akron, and their efforts to influence the routing decisions of the Nexus Spectra Energy pipeline. Greene sought to alter the pipeline's route to an area farther south and less populated. And although they largely failed to do that, I'm going to talk about, this is the circumstance that they're in for a number of reasons, is having to find lots of other ways to influence the pipeline's route because they otherwise don't have any opportunity under the legal context in which they're operating. So these are the three articles. I have two of them here. One of them's not yet out yet because these guys are working on it. Okay, so like I said, Ohio has a constitutional home rule where the local jurisdictions can't contradict or impede general laws. We've discussed about how vague that is, and local jurisdictions want to and have passed in Ohio ordinances and charter amendments attempting to ban or control oil and gas related activities. Not many have been challenged, but those that have been preempted by the state oil and gas law, which gives sole and exclusive authority to the Ohio DNR to regulate in that space. With respect to pipelines, it's a bit more complicated. I'll say it's a lot more complicated because they are controlled by the Federal Natural Gas Act, which, in terms of federalism, leaves to the local governments, not local governments, to state governments, the decision-making authority with respect to sort of subsidiary permits that have to be made. So where does that leave local jurisdictions? They're hoping to act successfully according to the interests and wishes of their constituents, their residents, with respect to where this pipeline will run. Some of the problems they face include federal law controls interstate natural gas pipeline permitting, and it is super complicated. State law often, and certainly in Ohio, heavily favors the utilities, and state law in Ohio preempts local efforts to influence or control these activities. So this study looks at what has Greene done to try to influence the pipeline's location, sort of in that context. Okay, I think I did. Yeah, that's what I'm looking for. There's your first picture. That is where the pipeline route was proposed to go, and if I can make this thing work. The little light. Oh, it's pretty dim, but there's Greene, and Greene is, that dot is the center of Greene, but it actually extends pretty far. It's a pretty big suburban area outside of Akron. A little bit more about the pipeline. This is a natural gas transmission line that was proposed to span 255 miles across Ohio, Michigan, and to a terminus in Ontario. And they had the rationale was to meet an alleged desperate need for the growing natural gas production in Appalachia. So to influence the route, it's important to know a bit about the process. Really their focus was, where is the pipeline route going to go? In terms of getting it approved, before you can get permission to build a pipeline, you have to have the route approved, and it has to go through an extensive pre-filing and filing process that includes route approval, review of new lines, environmental assessments, and coordination with a number of federal and state agencies. And all of this matters to local jurisdictions, so let's see what kind of influence they might have in this complicated process. Okay, so with respect to picking the pipeline's path, it involves the pipeline company coming in and evaluating existing maps and studies, sometimes doing their own. They'll have to conduct community meetings, and in this instance, Nexus sent out letters to citizens and to local governments inviting participation in the selection of the pipeline's route. They also had to carry out surveys having to do with engineering needs, civil engineering, cultural resource locations. There's geotechnical surveys and environmental related surveys that would fall into the Federal Energy Regulatory Commission's responsibility to do the environmental review as required under the National Environmental Policy Act. Some of those surveys required entry onto private land, which if I skip 2 ahead, you could see people didn't really like the entry onto private land. And this is what they thought was going to happen, that the pipeline was going to go right through their house that says, we're sorry if it causes you any inconvenience. Okay. So the process is governed by Section 7 of the Natural Gas Act and is overseen by FERC, the Federal Energy Regulatory Commission, which oversees the permitting process and acts as the lead agency under NEPA. That matters because of the public involvement opportunities that NEPA provides for local landowners, local governments, and other stakeholders to be involved in all of the information gathering and decision making that happens in that process. Lots of environmental permits are required on the federal level. NEPA, I won't go through them all right now in any detail, but for just as examples, National Environmental Policy Act, the Clean Water Act is involved here. Obviously, at the federal level, it's a federal law, but state water quality certification happens at the state level. The U.S. Army Corps of Engineers is involved. At the state level, there may be NPDES permits required. So it's an example, again, of environmental federalism. Coastal Zone Act, Endangered Species Act, National Historic Preservation Act, all of those may come into play, and they have various degrees to which there are opportunities for public involvement in those processes. But at the center, at the heart of decision-making is FERC, or the Federal Energy Regulatory Commission. If you're the local government and you want to be involved in influencing where the pipeline goes, there are other places where you might find opportunities for influence. One being the Ohio DNR, Department of Natural Resources, that's responsible for reviewing natural resources implications of the pipeline's route. Ohio EPA, which is responsible for the water quality certification permit issuance. As I mentioned, the Army Corps of Engineers, but you'll note that there are no local requirements or approvals are allowed in this process. So local governments can't get involved by issuing permits or additional requirements. I'm going to skip that because there's several lawsuits going on as we speak about it. But so I've been focusing on the city of Greene, Ohio, and what they've been doing to try to influence the pipeline's route. But also involved and challenging the route have been the cities of Oberlin, Bowling Green, New Franklin, and others. And the kinds of actions they've taken include things like passing an ordinance. New Franklin passed an ordinance banning oil and gas activities. Obviously, that's preempted in Ohio. Knock yourself out, but no. Bowling Green passed a charter, an amendment to its city charter banning oil and gas activities. Again, okay, preempted. All of the city councils involved have passed resolutions of disapproval. Thank you for your thoughts. They were all involved in meetings with the Ohio EPA chief, trying to influence the Ohio agency's issuance of the water quality certificate, basically saying, if you refuse to issue the water quality certificate, they can't get their pipeline permit, right? That was unsuccessful, and there have been a lot of lawsuits involved. This is what Green wanted to do, was move I think my little light is past its prime. But you can see the route that they proposed is red, and there were two. There was their alternate is the blue down there, and then there are some existing lines that are indicated. But really what they were trying to do is move the line south. And they submitted this proposal to FERC, and FERC just elected not to require Nexus even to study this plan. So that also was not effective. Green tried to negotiate with Nexus over the pipeline's route to try to get it to move, as I said, to lower population density areas. And Nexus initially agreed to make some small changes in the route, but the electric utility, First Energy, opposed that agreement, saying it was going to be in the way of its high power lines. So they weren't, Nexus tried to get Green to transfer easements voluntarily to Nexus so that it would very easily be able to get access to the pipeline's route. They did this by saying, here's what we believe these easements are worth. They were really just forms calculating the easement values, and Green said, no thank you, that doesn't sound like an offer to me. That sounds like you're just some useful information. And then not hearing from Green on their easement valuation forms, Nexus sues Green over the easements. Green participated in all of the administrative processes, attending FERC meetings. Interestingly, I had a long meeting with the legal department at Green and to try to understand their involvement in the administrative process, and they unanimously agreed that they had attended many of these meetings, and some of them that were supposed to be public meetings, there was nothing actually happening in the public meeting room, but people were going back one at a time into some back room for a discussion, and they weren't invited. Green sought to prevent Nexus, as I said, from getting its 404 permit, the dredge and fill permit under the Clean Water Act from the Army Corps. It sued it first appealed the issuance of the 401 water quality certification, filed an appeal with the Environmental Review Appeals Commission, all unsuccessfully. The Natural Gas Act gives them leave to directly petition to the Sixth Circuit. Yes, they tried. They tried using their own local ordinances, filing stop work orders in a number of areas. Nexus sued them on eminent domain grounds. Any case, there were a whole bunch of cases got consolidated in the Northern District of Ohio. And when the Sixth Circuit ultimately set a date for oral argument, it was actually going to hear some of these cases, Nexus offered a settlement to Green. I guess I'm behind. So everybody was suing. Green sued everybody in trying to get some positive response on this moving the pipeline. These are some of the parties they sued. Now, the primary result, it's not so good when this is behind you. The primary result here is that Nexus did ultimately, FERC ultimately did approve Nexus's request for what's called a certificate of public convenience and necessity. which is basically permission to move forward with the rest of the process. Interestingly, the Nexus issued its notice of commencement of construction, saying that they issued it on the 17th. It was a day late, but there it is. Let's miss this. That's what it's gonna look like. So in terms of what the local jurisdictions were able to achieve through this massive, broad, inclusive, extensive effort to try to use all of the other resources available to them, aside from what they thought they might have had through home rule, or was they got nowhere on the routing decision, but they did get a settlement from Green, and you can see up here what Green got. It was a very narrow win on the Green City Council in terms of approving it, but it did bring the city $7.5 million, in addition to some land that was purchased on their behalf to expand a park, and some assurances with respect to safety and monitoring of the pipeline, which have already to this day come in handy. And Green got what it needed, dropping lawsuits, got the easements. I'm almost done, if that's what you're about to tell me.
No, I'm making notes.
Oh, okay.
Fine.
Okay. I go on too long. Okay, but so this settlement that Green got, which to me appears to be about the best they could have done in light of the circumstances. The residents of Green were furious. They were livid. They thought the city had just failed them. And, you know, so you could see one of the quotes from one of the Green residents: "Not at one time did the city control the process of where the pipeline would go. Everyone, residents of Green, have a right to be angry." Really? You know, you're right. Not at one time did the city of Green control this process. The city of Green had no hope of controlling this process. And ultimately, the mayor says our options have run out, and by a very narrow margin, the city council passed the settlement. The law director was basically ousted from Green as a result of this, even though I believe it was the best result she possibly could have achieved in light of the circumstances. So what do we learn from Green's efforts? One, that law, history, and the administrative process are all on the side of Nexus Spectra Energy. As far as I know, to date, that no pipeline project has yet been derailed or substantially rerouted post FERC approvals. You know, in this Ohio case study, what I saw is lots of cities participated in the administrative processes and in the legal processes, and through lobbying efforts. I said they all went and met with the Ohio EPA. They participated, they opposed, they sued, and they lost. But I think that one lesson is that settlements aren't worthless. The city of Oberlin has still refused to accept a settlement with Nexus, and it had been involved in the process all along. At this point, what's on the table for Oberlin is, in terms of what Nexus is offering them, is a fraction of what, you know, Green got $7.5 million. I think Oberlin will be lucky to get $500,000. And they're going to lose anyway. So it's a shame there. So what else can local jurisdictions do? Not good from behind me. Is what we've seen local jurisdictions able to do is create ordinances regarding roads. Those matter to the pipeline company. Pipeline companies will actually contribute to road maintenance and improvement in deals with local jurisdictions that are going through their area. Local involvement can also include the same kinds of agreements with respect to utility use and maintenance. They have some control over easements where they're until the company uses eminent domain to get what it wants anyway. And they can have some involvement through mostly discussion and negotiation of construction and planning, and that's often achieved through using their traditional zoning authority. I want to get back for a minute to the importance of borders. I mentioned it at the beginning when we look at the legal context in various states, looking at home rule, whether they have home rule, how that home rule is interpreted and implemented, and whether or not they have preemption, broad or specific. It matters very much to these projects. Just last spring in May, we saw New York State reject a similar interstate pipeline, and the way it got rejected was because the local jurisdictions, helped by environmental activists, were able to impose upon the state agency to deny the clean water, water quality certification permit. So there you have the state or the local jurisdictions really pushing their state agency with some success. It's still being argued, but they haven't turned this one around yet. It's still been denied. That particular pipeline was a shorter one, much shorter, but like the Ohio Nexus Spectra Energy, it was an interstate natural gas transmission line, so it was subject to many of the same permitting requirements, federal, state, and so it needed the same thing, and basically what we saw the difference was Ohio EPA granted the water quality certification, the New York Department of Environmental Conservation denied it, and I guess I view that as a pretty big success by the environmental organizations and banding together with the local jurisdictions to exert influence on their state agency. But again, that all depends on what you've got for a state agency. Ohio's is very different from New York's. Okay, am I still okay? Okay, all right, I'm basically done. I got one more. Yeah. So in terms of next steps, what I'd like to work on is evaluating sort of not just the content, but the quality of local government participation in the administrative processes. I'd like to think about how we can seek increased roles for local jurisdictions in the state and federal permitting processes, because that's where they seem to be able to have some influence. And also to reflect more on potentially useful local actions outside the permitting and judicial processes, that is maybe perhaps focusing on traditional zoning authority. One of our Ohio Supreme Court justices says non-discriminatorily created and applied, meaning not focused on the oil and gas industry, but if you can create local land use ordinances through your traditional zoning authority and have it non-discriminatorily created and applied, it could perhaps withstand that state preemption and be able to stand. Okay. Thank you. No idea how much time I've got. Oh, would you like to use this? Oh, yes, thank you. Would you like a lesson? It has to be turned on.
Now, Genevieve Byrne's going to talk about state versus local with respect to siting of solar facilities. Yes? No. Yep.
little arrows down.
Hi, Genevieve Byrne. So just to give you a little bit of background on this project, I am the staff attorney for the Farm and Energy Initiative at Vermont Law School. We're funded by the USDA National Agriculture Library, so all of our work is supposed to sort of be national in scope, and for this program focused on issues at the intersection of agriculture and energy. So we've been looking at solar development sort of through the lens of farmland, both farmland protection and farmer access to clean energy, because it turns out solar development laws can both sort of roll out a lot of solar development on farmland and be a huge barrier to farmers participating when the rules are too restrictive. I also want to say thank you to two students who came down with me, Ludovica and Dan Brown, who've been working on this project for off and on for a couple of semesters.
Point it at the machine, not at the screen. The computer.
Sorry.
Next.
So these are just some examples of some strife that has come up with sort of local zoning and solar. Various towns passing moratoriums on solar development, or facing litigation over solar development, or needing to sort of scramble to create rules about solar siting once a state passes, for example, a very ambitious sort of clean energy goal that's going to roll out a huge amount of solar in the state. And so solar development seems like something that is a positive, right, that may not have that much impact. And in fact, there are a lot of examples of it being really good for farmers and farmland and supporting farm viability. So why so much strife? This is a land use that really didn't exist before 20 years ago. I mean, in the last 10 years, solar has really exploded. It's very different from the sources of power that we're used to, sort of large centralized sources of generation. It can go almost anywhere, and it is going almost anywhere, which is part of what's creating some of this conflict. We have municipal boards who may be responsible for approving this siting that have very little experience with energy, that have very little experience with solar, that haven't had practice sort of examining the land use impacts of this technology, as in fact not very many of us have because of the newness of the technology. Rapid expansion of solar across the country right now, it's generating almost 3% of US electricity need, 2.6%. That's 71.3 gigawatts of installed capacity. There are also the solar industry itself has expanded rapidly. It's overtaken a lot of other fossil fuel energy sources in terms of new job creation. We had nearly 250 million solar jobs last year, and that's supposed to increase by 8% next year over the 250 million that already exist. I think of solar as limited more by site type than by specific parcel of land. So you need just something that's relatively flat, relatively sunny, and relatively close to the grid to develop solar. And so that creates competition, land use competition for those parcels of land. Really, any undeveloped land is going to be sort of a good site for solar, but it puts a lot of pressure, particularly on agricultural land, often because farmers are in fact struggling to maintain farm viability. And so if you can bring in another income stream by putting solar on your land, you definitely want to do that, and you may want to do that regardless of what soils that land is, regardless of sort of what the long-term use for agriculture, how that may be impacted. Just to give you a couple of examples of the farm viability benefits, up in Vermont, Magnan Brothers Dairy Farm, which is over in Fairfield up near us, put a 150 kilowatt array just on 2 acres of marginal farmland. They receive lease payments to host that array because it's actually a community solar array, meaning that multiple customers or entities, essentially multiple houses, can sort of use the energy that's being generated by that array. And they've said that array helps balance the variability in milk prices. They're at 700 cow dairy farm that actually send some of their milk to Cabot cheese. And so they've seen a real effect on sort of their bottom line. Larger example, not just in sort of New England, out in Center City, Minnesota, Eichton's Hidden Acres Cheese Farm. They have a 5 megawatt array that's covering 21 acres, again, of identified marginal farmland. And they're receiving $800 to $1,000 an acre for 25 years. They say that's almost doubled the income stream of the farm, and they've planted pollinator habitat in and around the panels, which has been beneficial to other sort of local surrounding farms. That array also powers a local school district, an elder care facility, and some other properties surrounding the farm. So this is all good stuff, right? But creating strife, as we see in the articles. So to take a look at some differences in how states are handling solar siting, we've been focusing a bit on New England, though we are ultimately looking at how all 50 states are siting solar on farmland. And if you look at Vermont, New Hampshire, and Massachusetts, in Vermont, the state has entirely preempted energy generation regulation. So if you want to build any size of solar array, from a very small residential array up to a utility scale array, you need to go in front of the Public Utility Commission and obtain a certificate of public good. In New Hampshire, there's sort of more a divided authority over solar siting, where they have preempted siting authority for large-scale facilities. If you're an array over 30 megawatts, which there aren't a ton in New Hampshire, I just heard that I think like one array has gone through that. One array over 30 megawatts has gone through that process. You're in a sort of Vermont similar regulatory scheme where you're gonna go in front of the State Site Evaluation Council, receive a sort of similar certificate, and that's in both of those situations, you're sort of rolling in all of the other municipal permits, environmental permits that might have been required of this project. Massachusetts, on the other hand, has a much more municipal permitting process for solar. Technically they do have a state siting board for projects over 100 megawatts, but none of the solar projects are going through that process. And in both Vermont and New Hampshire, when you're talking about this sort of state level siting council, we're really talking about a trial-like adjudicatory hearing where you're going to have pre-filed testimony, you're going to have expert witnesses. And so deciding when that makes sense for a solar array versus when that might not make sense for a solar array, I think is one of the challenges that states and municipalities are facing. Both Massachusetts and New Hampshire do sort of direct their municipalities as to solar siting sort of implementation. they both have laws within their zoning code that saying that towns can't unreasonably regulate solar. In New Hampshire, they pretty much leave it at that. Towns develop their own zoning regulations. You go through the permitting process that's required by the town. In Massachusetts, they definitely do not leave it at that, even though you would look at it and say, oh, I need a local zoning permit to permit my array. They layer a lot of land use and siting requirements into the rates that you can get paid for solar energy in the state. And they also someone used like punitive preemption. I don't know if this is quite the same thing, but they run a green communities program where in exchange for passing sort of permissive solar zoning, the town can then get grant money, technical assistance, and other help from the state. So even though it's a sort of municipal process, the state really has a huge hand in the solar development policy in both the size, sort of location, and design of these projects. So just to get a little bit more detail on the Green Communities program, the criteria that the towns would have to meet to actually take advantage of the benefits, the grant money, the technical assistance. First, they have to agree to cut municipal energy use by 20% over the next 5 years. They must pass zoning that designates solar as an as-of-right use in at least certain areas of the municipality. They also have to adopt expedited permitting for certain solar projects. Expedited meaning it would take less than a year to get through that process. If practicable, they have to purchase municipal fuel-efficient vehicles for the municipality, and they have to agree to minimize life cycle costs of new construction. So if they do all of that, then they get money, and a lot of the communities really are doing it. 240 different towns in Massachusetts have gone through this process. So when we say it's a municipal process in Massachusetts, it is, sort of. Let's go to the next. So this very complicated chart sets out the process in Vermont. Vermont has, as I said, preempted all municipal control of solar siting. So when you go to the Public Utility Commission, they've worked to do some of that decision making about what happens to a sort of really small scale array versus what's going to happen to a much, much larger array. If you're up to 15 kilowatts, this is pretty small scale. One house, if you think of a residential array, it could be anywhere from like 7 kilowatts in capacity, maybe up to 14, 15 kilowatts in capacity. So this is really trying to target those extra small scale arrays, as well as roof-mounted arrays up to 500 kilowatts. Roof-mounted can go through this sort of expedited process as well because they're not having the same land use impact, right? You're putting it up on a structure. If you meet the criteria for this sort of first, easiest, fast-track process, then you're getting your array approved and getting your certificate of public good basically in 10 days. You are deemed approved unless the utility complains that the array is not good it's not in a good place in terms of grid reliability needs. 15 to 50 kilowatts, an application process. That's getting more into the adjudicatory hearing type process, but there are fewer criteria that the Public Utility Commission is going to apply. And then for much larger scale arrays, you go through this whole petition process with all the expert witnesses, pre-filed testimony, stakeholder involvement, public hearings, and the whole kind of rigmarole. They've layered a lot of other rules into the solar siting, the Certificate of Public Good. They do have decommissioning requirements for projects above 150 kilowatts. And if you get much larger than that, then you also need to put up sort of a bond or identify funds for decommissioning. So this is all permitting process. And when you think about why this matters, if I have the same permitting process for a 15 kilowatt array that's supposed to serve one house versus a much, much larger array that might be, could power a whole neighborhood, then my regulatory incentive there is sort of to get the most bang for my buck, right? I am probably incentivizing, even by accident, much, much larger scale development, and I'm actually making it much harder and much more expensive for individual homeowners, individual farmers, individuals to put on those sort of smaller scale arrays. Let's go to rates. So I said that Massachusetts sort of layers all of these siting and land use requirements into its rates. It's even more complicated than the Vermont process, but it's sort of similar, so we're using Vermont as an example. In states that are promoting renewable energy, you often have a net metering program where individual electric customers or communities, groups of customers can get together, put an array, what we call behind the meter, as in that array is going to be sort of powering that house first and then contributing energy to the grid. They can get paid for the energy they can contribute to the grid and then would only pay for the extra energy that they need to take if their array didn't generate enough power. For larger systems, you're often going to have a feed-in tariff or another contract that the state has made available to get paid a rate over the next 10 years, for example. So the states are putting adders and subtractors into these rates to incentivize things like array size and location. So in Vermont, if you have a very small scale array, no matter what location it's in, you get an extra cent per kilowatt hour on your rate. If you're sort of medium sized, but not on a green field, you're gonna get a 1 cent adder. If you're a large scale array and not what's called a preferred site in Vermont, then you're gonna get dinged like 3 cents per kilowatt hour on your rate. Over time, we're talking about 10-year contracts. This makes a huge difference. Also, if you get a negative rate, it doesn't just last 10 years, it actually lasts the lifetime of the project versus the positive rates that apply for 10 years. So what the state has done is create a list of preferred sites for solar development. And these are the sites that are eligible for these incentives. You can see the sites that we think are good, existing structures, so you're not doing ground-mounted arrays, landfills, brownfields, Superfund sites, previously developed land, anywhere that's not sort of pristine, undeveloped open space. This is where I want to come in, talk about Vermont's sort of inclusion of municipal preference. So Vermont passed Act 174, which requires municipal energy planning. Towns and regions have to go through a process of energy planning to identify sort of site types at the municipal level. So look at your town and tell me what areas of your town might fall into those different categories, and also what what areas of your town you think would be great places to site solar, and what areas of your town would be bad places, conflict-inducing places to site solar. Once they go through this process, the sites that they've identified as good sites get the same rate adders as the sites that the state has identified. And let's pretend a site is not on anybody's list. You can actually go to the local planning board and the regional planning commission, get a letter from them. If they both agree, then you can get that individual site added to the list and get the incentive. So once you do this, when the project goes to get its certificate of public good from the Public Utility Commission, then the commission is required to give substantial deference to the town energy plan and the ordinances, the locations that they have put in the town energy plan. I think I'm running out of time too. So how can I feel like we've been talking a lot about preemption as a bad thing. And I'm not saying that this is a perfect process, but I think that at times, at least, this process and these sort of state level siting boards are undermining local authority for the better, dare I say. It takes a lot of pressure off of local boards, and energy is something that the state often has expertise in at the state level versus at the local level. Public utility commissions are often the ones working with utilities to do long-range energy planning, to understand where the distribution grid is and where the pressure points on the distribution grid is, where we should be adding more distributed energy resources and where we already have too many generating resources getting contributed to the grid. Regardless of whether you're in a state or local process, I think it is municipalities who need to be making those parcel-specific determinations, where this piece of land over here is not good for development while this piece of land over here is. So if the state is preempting local authority over things like solar siting, I think maintaining an avenue for that municipal preference, municipal opinion is incredibly important. So just broadly speaking about sort of state policies that affect solar siting and can kind of direct that process, establishing, a state can work to establish categories of project. What do we think is a small scale solar project? What do we think in our state is a large scale? So what is community solar? Creating those definitions that either the state can use or a municipality can use if you are in a state that has a municipal siting process can be really helpful. At the same time, you want to create those definitions of different land types. What is agricultural land? What is marginal farmland? What is previously developed land, if that's something we're incentivizing? I think that states or municipalities need to be doing sort of fast tracks for these small projects, roof-mounted projects, projects that are basically good public policy. And I didn't get into current use taxation at all, but I want to touch on it just momentarily. Most states have a beneficial taxation program for agricultural land, where instead of getting taxed at the market value of your land, you're getting taxed at the agricultural value of the land. And so if you're putting solar on projects that are enrolled in current use, you may risk getting penalized, getting tax penalties, rollback taxes on that land, and essentially getting kicked out of the current use program. So states have started making rules about this. When can you add solar to land enrolled in the current use program? And this is another thing that I think is sort of useful for the state to address at the state level and just make a rule about it. In Vermont, you can use up to, you can meet the energy needs of the farm, so 100% of the farm's electric needs, and then an additional 100% to sell without violating current use for the most part. In Massachusetts, you have to be doing a dual use or agrivoltaic project, meaning that the agricultural use has to continue. Things like pollinator habitat, the first photo was sheep grazing in and around the panels. The University of Massachusetts Amherst is doing a lot of work on what crops can grow in and around panels so that you can literally get 2 income streams off of the exact same parcel of land at the same time. So making rules for current use and making rules that sort of incentivize those agrivoltaic systems when solar is centered on farmland is important. And I think I have to stop now, even though I've been talking about this for a long time.
Thank you. Maybe get back to Sarah after you've heard Heidi and Genevieve's talk. Any thoughts on how that relates to your concept of environmental federalism?
Yeah, I mean, you know, it was very interesting to hear these very specific examples of really environmental federalism in play. And I mean, I totally agree, right? There are instances where if a state has a robust regulatory program, well, then maybe the state should have, you know, then the state is kind of doing what it needs to do there. And we can talk about ways local governments can get involved. But I find that much less kind of problematic in terms of thinking about, you know, a robust, functional environmental federalism system. And so I think that, you know, going to kind of what Heidi was looking at in terms of ways that we need to think about how local governments can and are actually able to participate, that's what I find very kind of interesting and potentially problematic, is where there's failures of local participation. I think that's worth kind of examining. And then if local governments don't need a role, then maybe that's the answer in a lot of places.
Questions from the audience? Heidi, I got a question for you on the comparison between Ohio and New York with respect to denying or granting the 401 certificate.
Yeah.
And I mean, what is the relationship of like the state policy or the control of the governor over
Huge.
DNR in Ohio versus New York?
Huge, 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 huge. And that goes all the way back to, if you look at, you know, I'm going to put your question just a little bit aside and say that both Ohio and New York had lots and lots of local jurisdictions wanting to ban fracking, for example. And that the question was, can they, right? This earlier one looked at kind of the differences between those 2 states. And Ohio is just very different in terms of the legal context there. For example, we have home rule, but it was interpreted that kind of decision is not part of home rule, and it went all the way up to the state Supreme Court, and the state Supreme Court said, nope, sole and exclusive authority with respect to oil and gas related decisions goes to the Ohio DNR, no local decision making. The decision in New York was different. Their constitution is different. Their Supreme Court makeup is different. And, you know, that just kind of goes back to the importance of borders, right? And, you know, the same thing is true with respect to the granting or denying of the water quality certification permit. That New York's Department of Environmental Conservation is just very different in nature from Ohio EPA and is much more likely to be influenced on the side of the environment than is the Ohio EPA. You know, so it does come back down to the kind of the politics of the state.
Question in the back there.
Yeah, I hear ban fracking, ban unitization, ban pipelines, and of course where I live in the Eastern Panhandle of West Virginia, where we don't have any of those problems at all. How do we encourage, and should we encourage, the development of solar? I mean, should our city become energy neutral or carbon neutral? Should we encourage our citizens to do that? And if we should encourage them to do that, what are the strategies we should use to encourage citizens of our town? What home rule things can we do that would make that better?
Well, I definitely think that you should be encouraging it. I'm from West Virginia. I'm also from the Eastern Panhandle. I'm from Shepherdstown. And I think so much about West Virginia's identity as an energy state. We have mountaintops that are relatively flat on top right now, right? With roads and infrastructure leading up to them and around them. We could be incentivizing solar, wind, other forms of energy generation. You could be exporting that energy out of this state if incentivized properly. I think having a net metering program, a robust net metering program, is a really simple first step. At the local level, I think permissive zoning for solar is important. Have your town go through that process of energy planning. What sites do we think are good? What sites do we want to make solar an accessory use, an as of right use in the zoning code? Those are some of the very first steps. And I think that, there's a lot more that can happen at the state level, but those actions can certainly happen at the local level.
Can I say one more thing? Sorry, I just want to emphasize that I think that the perspective I look at this stuff from is that not every municipality looks at these decisions the same way, right? Some of these jurisdictions, local jurisdictions, they want to ban fracking and they want to ban natural, oil and gas production, and others want it. They want it to come to their communities because it has some economic value. So it's not that I think preemption is a bad thing. I think there is a place for preemption where it makes sense to have a statewide system. It's just that I would like to see a system that is more open to local involvement in the decisions that are made, and that appears at least to be listening to the will of the local jurisdiction one way or the other, instead of preempting all involvement.
Yeah, just one last thing. I would just say a lot of times, all you can do at the local level sometimes is remove barriers, right? Especially in the context of energy development. There's going to be a whole state framework that's in place, but I do think evaluating, right, your building codes, your zoning ordinances, and making sure there's not kind of elements of those that are going to prevent people from even going down that road is a good first step. And I would just say, as a practical suggestion, for your community or others, there's this kind of national sustainable development code that's being kind of worked on, where it has a website, Sustainable City Code, and if you go on there, there's a ton of different examples, just really kind of model ordinances that local governments, it's focused on smaller communities, not the giant metropolises, but like smaller communities, and the actual actions they can take on things like energy development, other sustainable development measures. And so that can just be a kind of practical, helpful resource to generate ideas for what even to look for in kind of terms of, things that might exist in your building code that would be worth taking a look at.
Okay, with that, we're out of time. Let's thank our panel.